start out, we're going to have Donna Guerrero. Can I say her last name?
Good, yeah.
All right. She is the director for the University Copyright Office, and she's going to talk to us about the CIC addendum and ways that we can preserve our rights when we publish. And so this information I thought was very important for graduate students, as most all of us have to write a thesis or dissertation, and if you're going to publish a paper before you write that, this is one nice way that you can avoid a lot of headache. I don't want to steal your thunder, but it's important information that I hope you guys can retain and also be able to bring back to your constituents in your departments. And so, anyways, Donna is an expert in this area. You have a law degree, right? And so she's amazing. Anyways, I'm just going to turn it over to her, let her tell you all about this, and then we'll have questions at the end. So please feel free to ask her any question you have about what we're going to talk about. All right, thank you, Donna.
Thanks, Andy. Okay. Thanks for being here. I'm really delighted to do it. We're going to talk a little about author rights and more author rights in general, not just the CIC addendum, because if you don't know about it in general, you're not going to really understand what CIC addendum is about. So, anyway, we'll do this fairly quickly because I hope you're all on a pizza high for the first 10 minutes, and then you can ask questions after that. Pretty much what we're looking at for copyright is it goes way back to the U.S. Constitution. And that's where we get our rules and regulations from, okay? And it talks about that you secure for limited times the rights to authors to their works, all right? So when we're looking at the copyright law, we're actually looking at a federal law. So if you violate it, you go to federal prison instead of state prison, and that's natural. I don't know for a fact, but that's what they tell me. So when you are working with the copyright law, basically we're working with the 1976 law. There have been some added changes since then, but it doesn't take into account a lot of the digital things that we do these days. So you'll see a lot of holes in the law. And so we have to try to really balance what we think the law says with what's happening with technology and that kind of stuff today. Anybody ever see that C in the circle, that copyright symbol? Okay. That's no longer required on works to have them protected under the U.S. copyright law, but I advise you all to use it and to put your name and the year of publication of whatever you have if you're publishing something yourself, and kind of retaining the rights to it. Reason being is that if someone wants to use your work, they can find you, track you down, ask permission to use it if they need to do so. But it's no longer required under the U.S. copyright law. You no longer also have to register your copyright with the U.S. Copyright Office. That's something that also went away. If you want to do that, you're more than welcome to do that. It's very inexpensive. The reason most people will register it is basically to say to the world, I'm the first one that had this article, this book, this movie, this whatever. Okay. Just so you know, that's what you can do. You don't have to, but you can. One thing about copyright, and this is something that confuses a lot of people, is that they do think they have to do something in order to get protection under the U.S. copyright law, and you do not. There's only two things you have to do. It has to be an original work, and it has to be what we call fixed. And by fixed, it means either you can see it or a computer can read it. So we are talking about anything that's recorded, or a photograph, or a book, anything like that. Okay, those are the only two things that you need in order to be protected under U.S. copyright law. Okay, this is a whole category of works that are protected. You won't have to read them. You can see them. Pretty broad list of works that are protected. The things that are not protected are things like ideas. Okay, we can have all have the same idea in this room, but it's the expression of that idea. Okay, that's protected. Titles, names, short phrases, slogans, they're not protected with the U.S. copyright law. However, they are protected generally under something called trademark law. And I'm not an expert on trademarks, so we won't go there. But if you started using Nike slogan, just do it, and they're making money out of it, Nike's going to come calling, but it's not a copyright, it's under trademark law. Okay? Facts are not protected. And then there's a whole category of works called works that are in the public domain. And when works are in the public domain, it means that they're free for you to use. You don't have to ask permission, you don't have to pay royalties. You just use them. There are two categories of works that fall into that category. One are works that are produced by the U.S. federal government. Okay, so if it's a federal government document, you can use it any which way you want. Be aware state documents are protected, so it's only federal documents. And any works with expired copyrights. And pretty much what I can say right now is that works that were published in the U.S. prior to 1923 are in that category. Okay, you have to assume that anything from 1923 to the current time is still protected under the U.S. copyright law. Okay. Anybody here already a copyright owner? Come on, you have to be, at least one has a copyright in something. One person does. What do you have a copyright in?
Play.
A play, okay. Any one of you ever send an email? No one here sent an email? Okay. Wow, you're the first group of students I ever met that never sent an email. Anybody take a photograph? Okay, you're all copyright holders. Isn't that exciting? You didn't know you had such power. You're awesome, okay? You have rights now. These are your rights, so make sure you understand them so you can always be right, okay? You can reproduce those works, okay? Make copies of them. You can give them to anybody you want. That's your choice. If you're an artist, you want to display something, you can do it. You have a play, you might want to perform it, okay? You can publicly perform that. And then you have the right to authorize derivative works from yours. Those are all your rights. You have so many things you can do. That's wonderful, okay? And you have it for an incredibly long time. Right now, it is for your entire life, plus 70 years after you're done. So if your play is really successful, your heirs will make lots of money off you after you're dead. So isn't that a nice thing to know? You're helping posterity here. So it's a really, really long time copyright is in existence for. So it makes it critically important that you understand those rights and how you need to maintain some of those rights or retain some of those rights. Okay? A lot of times we do works with other people, and those are called joint authors. I won't go into the details of that, but I just wanted to point out that when you are a joint author, you have mutual responsibilities. One of the things that you have to do is, if you are going to make money off of this, you have to split the money equally, okay? The other important piece to this is when you are a joint author, you can enter into a non-exclusive license, which means you can say to your friend, if you want to use this, go ahead, okay? And then you can let anybody else use it as well. But if you enter an exclusive license, which means you are just allowing one person to have the use of that forevermore, you have to have all the consent of all the authors, okay? So that's just something for joint authors. One of the things that we're seeing a lot in terms of publishing is that it's changing how you publish. And it's something that you need to be aware of. But right now, you own the copyright to any of the works you produce here at Purdue, unless, of course, you've signed away that right in some way or another, I don't know. But what we're seeing a lot more different kinds of publishing coming along, whether it's self-publishing, whether it's publishing for limited times. The big, huge publishers are now kind of merging, okay, so there's not quite as many out there. And so you have to look at why some of this is happening. Obviously, the internet plays a big role in that. You can get gratification immediately because you can post something and get some reactions to that. Cost, it's cheaper sometimes for you to do it yourself than to give it to somebody else to do, okay? And then there's also something called open access, which is where people encourage you to post it, okay? You still retain your copyright, but you post it and allow other people to use it under certain conditions, okay? So there's some of the reasons why we're doing it. Now you've come along and you have an article that's accepted for publication, and you're so excited. You say, hey, now I'm a real official copyright holder. But then what happens, okay? Anybody have an article published already? And a few of you. Did you get a copyright transfer agreement in the mail? Did you sign it? Oh, someone's shaking their head. No, I like that. No, you didn't?
We did the addendum. It was required.
Okay, good. Good man. Okay, come up here. You can talk about it. No. Just teasing. Okay. Generally what you're going to get is something called a copyright transfer agreement or copyright assignment agreement. And basically what the publisher is saying to you is, in exchange for us publishing your work, you transfer the copyright in your work to us, okay? Now, we're all desperate for tenure or something, right? We want to graduate, we want to do something, so we'll sign it away, okay? Problem is it will come back to haunt you later. I understand why we sign it away. I've done it myself because it's that publisher perish kind of thing that goes on. But you have to be aware, when you give them your copyright, you can't use your own work, right? So that's not a good thing. You want to be able to use it. So you have to start thinking about what you want to do with your work. So you have something that's publishable, you've contacted a publisher, and you said, okay, if I want to retain some rights, what kind of rights do I want to retain? So if you're thinking about posting it on a website, you have to think about that. You want to give it to some of your colleagues, okay? If you want to use portions of it or all of it in another publication, right, can you do that? We have an institutional repository here at Purdue. And if you wanted to add it to that, you have to retain some of that copyright. You have to have the permission from the publisher in order to do that, okay? So just understand it's very critical because right now you might not think it's all that important, but down the road you will find out that you're really going to need to have some of those copyrights. Again, those are the rights that you have, and you want to make sure you do something with them. When you get that agreement, I say negotiate that agreement. You have the CIC addendum. I didn't know how many there were going to be here tonight, so I only brought 20 copies of it, but there's some up front here, as well as an author brochure, author rights brochure that my office publishes. If you want more of them, Andy knows how to contact me. Just contact Andy, and I can get you as many as you want, okay? So when you're getting that first contract with the publisher, you want to make sure you understand what it says, okay? Don't just sign it and then throw it away. I cannot tell you how many people do that. And then they come to me years later and say, I want to do this, and they're telling me I can't do it. And I say, well, show me the contract. And they say, I don't know, was that a contract? I said, it was. It's a legally binding document, so make sure you retain it and understand what it says. Negotiate it, okay? CIC author addendum is really good. It's something that the CIC group, the Big Ten group, got together, and they looked at all kinds of other agreements that are out there to say, okay, generally, what do faculty or students want to retain? And they looked at it and said, well, there's a lot of things that we need to do with our work, and we're going to talk about that in a minute. And so that's what they put this document together. It's something that Purdue as an institution recommends that people use, but it's not required to use, because we understand that sometimes people need that flexibility in order maybe to get published, to do whatever they need to do. There's some other things out there that you can look at. Always be aware that there's exclusive licenses versus non-exclusive licenses. There's something called Creative Commons. Anybody here Creative Commons? A couple people. Okay. If you go to Creative Commons, they have some sample licensing language, so that if you wanted to allow people to use your work for certain reasons, they give you some examples of how to do that. There's also a couple of databases, Sherpa Romeo and EBSCO. Before you even decide that you're going to publish with a specific journal, you might want to check in one of those databases or both of them, because what they do is they list publishers' agreements with authors, so you can see if they're copyright friendly or not, and then you might decide which way you want to go in terms of what journals you would like to submit your article to, okay? So the CIC author addendum, okay, when we're looking at that, you're basically retaining some of the rights. And one of the most important things that we see now are the embargoes, where the publisher will have exclusive right for a certain amount of time. It usually varies between 6 months and 12 months. And then you can deposit it into the institutional repository or to one of your societies or whatever. Okay? You can use the works for your teaching and scholarship. That's something that's very important for us. So you want to retain those rights. Okay? And it's something that allows your institution to also use the works for certain scholarly and educational activities. So those are the main themes of the CIC addendum. It's very broad. That's why we like it. If the publisher will accept it, that's great. Sometimes you will attach it to the contract, and they will come back and say, we don't want it, or they'll say, we love it, we're going to do it. Okay? So you just never know, but you have to be willing to negotiate, and that's really important for you to do that. The Creative Commons license, I'm not going to take a long time, because I want to make sure you have time for questions, but it is something that gives you some suggestions if you want to have people add to your document or not, or share it or not. Okay, those are things that we're going to allow you to do. There's a lot of these open access mandates out there. Anybody who works with NIH understands that if you're going to get any of the money that they are handing out for funding, then you have to deposit any results of that research, basically generate articles, in what's called PubMed Central within 12 months of publication. If you don't do that, the university can get right there about the money that they given from NIH for the grants. Okay? Harvard, MIT, Duke, all of these different ones have open access mandates where the faculty has agreed that they will put their articles, their works in the institutional repository, and then publishers can publish it, but it must be basically free to the world to be able to read and to see. Okay? So just because we're talking about open access, if you want to go that route, it's a good route. Understand that you retain your copyright, you don't give it up, and if you're using other people's open access works, they retain the copyright, so it might be free to access, but not free to use. Okay? For that. And just the final point is, you have to manage your copyright. Okay, it's an asset of yours, and you're going to need that as you continue on in life. And so make sure that you understand whatever it is you're signing, that you want to manage that well, so that you can use your works in whatever way you choose. okay? And that's it.